Former Alaska Governor Sarah Palin's defamation suit against the New York Times has just been revived by a federal appeals court. The suit was originally filed back in 2017 and claimed that an editorial by the Times was defamatory because it incorrectly linked her to the mass shooting that killed 6 people and severely wounded then Congresswoman Gabby Giffords. A spokesperson for the Times said in response, "This decision is disappointing. We're confident we will prevail in a retrial." Joining me now, MSNBC legal analyst Danny Savalos. Always good to see you. This went to trial in 2022. The jury, as we said, sided with the Times. How did the appeals court come to this decision?
Before the jury sided with the Times, what happened was the judge granted what's called a Rule 50 motion, and this is called a judgment as a matter of law. In other words, the judge concluded while the jury was deliberating and before they came back that no reasonable jury could find in favor of Sarah Palin. Then the judge allowed the jury to come back and they entered a verdict of not liable. Now, you may take a step back and say, well, it sounds like the judge predicted right. The judge said the defendant, the Times, wins, lets the jury come back, and the jury says the defendant, the Times, wins. But those are very different standards. What the judge concluded was that no reasonable jury could find in favor of Palin. In fact, a jury found not in favor of Palin, but that's not quite the same thing. The appeals court found that there were other problems, including the exclusion of Sarah Palin's evidence in the form of news articles that she wanted to admit, and some other concerns, including jurors receiving push notifications while they were deliberating and learning that the judge had already dismissed the case before they came back with their verdict, which, of course, that's a real problem, because if you're a juror and you're deliberating and you've already gotten word that the judge on the case thinks there's no case, well, that puts you in a different mindset, I would imagine, or at least that's what I would argue if I were Palin.
So what happens now?
It's remanded, new trial. Ordinarily, what this does, it doesn't necessarily mean the case will go to trial, because ordinarily parties might say, OK, new trial, what's the business cost to us of going through this again? Let's settle. I don't know that Palin's going to do that. I think Palin wants to make new law. She has argued that the New York Times v. Sullivan standard, which has always, you could say, protected journalism by requiring a higher burden for a plaintiff to prove when they are a public figure like Palin to make their case for defamation. But Palin has indicated that she wants this case to make new law, and that might mean going to the Supreme Court and challenging New York Times v. Sullivan, which has always required a kind of higher burden for public figures to prove defamation, often against journalistic outlets.
Given everything that's surrounding this, if this is retried, could it be difficult to get a jury, to seat a jury?
It's always difficult to seat a jury with a high-profile party, plaintiff, defendant, whatever the case may be. But just look at in New York City not too long ago, the court seated a jury in a matter of days for the former president of the United States. So it's always difficult in a high-profile case. Different courts have different levels of success. One RICO case in Georgia, in Atlanta, took 8 months to seat a jury in a high-profile RICO case against a recording artist. Here in New York, 3-4 days to seat a jury for the former president of the United States. It's always a challenge. Every judge approaches it differently, but sooner or later, we've learned that we always can seat a jury eventually.
How long could this take?
I would say quite a long time, because if you read the appeals opinion, there was a lot of evidence introduced and some of it was excluded. I don't think that would add too much on to the timing, but this is a case that had a lot of moving parts, a lot of evidence, a lot of documents, a lot of things for a jury to consider.